agenda, we'll vote on 5 judicial nominees, 2 nominees to the U.S. Sentencing Commission, 2 U.S. Attorney nominees, and 1 U.S. Marshal nominee. There's also 1 bill on the agenda that will be held over again, S-1306, Cops Reauthorization Act. The first nominee we will consider today is Judge Nancy Maldonado, nominated to the U.S. Court of Appeals for the 7th Circuit. In addition to a unanimous, well-qualified rating from the ABA, she has the strong support of Senator Duckworth and myself. Judge Maldonado graduated from Harvard, Columbia Law, before clerking for my friend, U.S. District Judge Ruben Castillo on the Northern District. She then began her career at a law firm specializing in plaintiff-side employment, civil rights, and fraud cases. She has also served the people of Cook County as a Special Assistant State's Attorney and the people of Illinois as a Special Assistant Attorney General, tasked in both cases with investigating fraud. In 2022, she was confirmed on a bipartisan basis to the Northern District, became the first Hispanic woman to serve as an Article III judge in Illinois. I want to take a moment to address questions that have been raised concerning the number of motions pending before her. In her nearly 2 years on the bench, Judge Maldonado has presided over almost 1,000 cases, ruled on thousands of motions, and issued approximately 300 substantive decisions. Of the nearly 1,000 cases that have been assigned to her, she has resolved over 650 since October 2022. Notably, she has never been reversed by a reviewing court, not once. To claim that she does not move cases quickly enough ignores how cases have been assigned and resolved in the Northern District. For example, 3 district judges left the Northern District within the first 3 months that she joined the bench, meaning that she received an unusual number of reassigned cases on top of her initial batch of assigned cases. And because district court rules preclude reassigning a case more than once within 12 months, judges who were confirmed after her could not receive many of the cases that had already been assigned to her. Throughout her time on the bench, she's demonstrated a commitment to carefully resolving cases in a way that ensures litigants feel they're being treated fairly in her courtroom, and she's issued opinions that carefully apply law to the facts. I look forward to supporting her nomination. Today, we also vote on the nomination of Georgia Alexakis to the U.S. District Court for the Northern District of Illinois, a first-generation American. She was raised in Chicago, attended Harvard and Northwestern Law, clerked on both the 9th Circuit and Northern District of Illinois before beginning her career in private practice. Since 2013, she served as Assistant U.S. Attorney for the Northern District. She was previously in the Office of Civil Rights and Hate Crimes, which required her to work closely with the FBI. She now serves as Chief of Appeals and has spent a significant amount of time litigating before both the Northern District and the 7th Circuit. She'll be a strong addition to the federal bench. With that, I'm turned to Ranking Member Graham and then Senator Grassley for opening remarks.
Senator Grassley, I'll defer to you. Okay, then I'll say something. Go ahead.
Mr. Chairman, I'm just going to...
Your mic, short.
I'm going to speak about the 2 nominees for U.S. Attorney for Iowa. I've kind of had an experience over a year long dealing with the White House on this, similar to what Senator Tillis told us, that he has had problems with some judgeships. But I'm glad that we've reached these agreements. I'm pleased that this morning we'll be considering the nominations of David Waterman, Matthew Gannon, nominated by President Biden to be U.S. attorneys for the Northern District and the Southern Districts of Iowa, and that's respectively as I named them. I joined with my colleague Joni Ernst in supporting these 2 outstanding Iowans. Mr. Waterman is a 5th-generation lawyer at Davenport Law Firm of Lane and Waterman. Previously, he served as an assistant U.S. attorney in the Appellate and Criminal Division of the U.S. Attorney's Office, Middle District, Florida. In addition, Mr. Waterman served as a judicial law clerk for 3 federal court judges, Judge Michael Malloy of the 8th Circuit, Judge Mark Bennett, Northern District Judge, and Judge John Harvey, U.S. District Court for the Southern District file. Mr. Waterman received his B.A. summa cum laude, George Washington University, Master's in Philosophy, University of Cambridge, and his J.D. degree from the University of California, Los Angeles School of Law. Mr. Gannon served as the first Assistant Attorney General for the Iowa Department of Justice under former Attorney General Tom Miller. Previously, he served as an Assistant Attorney General for the Iowa Department of Justice and as an associate at the Washington, D.C. law firm of Arnold and Porter. Mr. Gannon received his BA degree magna cum laude from the University of Notre Dame and his JD with high honors from the University of Iowa College of Law. I'm confident that these two highly qualified nominees will faithfully serve the people of Iowa. I endorse both. I want to emphasize that both Joni Ernst and I have returned the blue slips on these people. I've been told that some of the colleagues on my side of the aisle may vote against them. I hope that they would take into consideration that when we had blue slips from two Republican senators of the same state, I've tried to honor that compromise, and I'd appreciate the same respect. Thank you.
Thank you, Senator Grassley. And before I recognize Senator Graham, let me say that thank you for turning in the blue slips with the Democratic president for two people you believe in that could serve as U.S. attorneys. Since last June, one of our fellow senators, a junior senator from Ohio, has put a hold on U.S. attorneys to protest the treatment of the former president. I hope he'll reconsider. We need good people from both sides of the aisle to serve in these capacities. Senator Graham.
Thank you, Mr. Chairman. Yesterday, we dismissed impeachment charges against Secretary Mayorkas that were delivered by the House, and the rationale by the majority leader was that the conduct in question did not arise to a high crime or misdemeanor under the Constitution. Well, Article 2, I'm not going to bore the committee with a lengthy dissertation, basically accuses Secretary Mayorkas of misleading and lying to the Congress about the status of our situation on the border. If that's not a high crime or misdemeanor, I don't know what would be. We impeached President Clinton for giving false testimony in a civil deposition involving a civil lawsuit. So what's the concern? That Secretary Mayorkas has been misleading the country and the public, and my concern is about parole. I asked him in November 2023, do you do a case-by-case analysis? This is to Mayorkas. Senator, we comply with the law. So there's a file for all 240,000 where somebody determined they met the two criteria, urgent humanitarian need or significant public benefit. There's an individual determination made on all 240,000. I can see that. Yes, Senator. I'm asking for that. So in your opinion, 240,000 people are individually screened and granted parole. You're not blanket paroling people, are you? That is correct. So the bottom line is, what do we now know? That the parole statute requires parole to be limited to two things: urgent humanitarian need for the person, maybe your mother's dying, something going on that's really urgent, or you have a special benefit to our country, which may be you're a witness in a cartel trial. Not just to come into the country on parole because somebody at DHS wants to make you come into the country. So what have we learned? 2 days ago, we learned that the man charged with killing Laken Riley, Mr. Ibarra, was paroled because there was no space in the El Paso detention facility for him. That's why he's paroled, due to detention capacity at the Central Processing Center in El Paso, Texas. That's not a valid reason to parole anybody. So I would argue this is Exhibit A of where the statute and the actions of the Secretary do not match, and the testimony that he gave to the Congress doesn't match. You've decided to dismiss this case without any inquiry, judicial, Senate review, first time in the history of the country, and the argument that you make is that the conduct alleged by the House doesn't rise to high crime or misdemeanor. That is stunningly bad for the Senate, bad for the country, and the only thing left now, I guess, for the American people is to decide this issue at the ballot box. But the Senate, in my view, yesterday went down a path that no other Senate in the history of the country has done, and that is to dismiss charges serious in nature without any really inquiry by the Senate itself. So very disappointing, and thank you for the time.
I just want to add one point. Yesterday could have been much different. The first motion made by Senator Schumer was to a unanimous consent request, which would have created an opportunity for more discussion and debate. It was objected to by one senator, the junior Republican senator from Missouri. Otherwise, we could have had a much more fulsome experience than we did yesterday.
Mr. Chairman.
Senator Cornyn.
Mr. Chairman, that really begs the question. The Constitution and the rules of the Senate require a trial. And what Senator Schumer proffered with a unanimous consent request was not a trial. It was some abbreviated debate on a motion to dismiss. So as the presiding officer acknowledged last night when I made a parliamentary inquiry, this sets a precedent in contrast to the requirements of the Senate rules and the Constitution, which would require a trial once the House votes on articles of impeachment and sends it to the Senate for a trial. This sets a new precedent. So what our Democratic colleagues have done is provided that if there is a future impeachment of a president of the United States, let's say by a democratically controlled House, and it's sent to the Senate, that can be summarily disposed of without actually having a trial. That, to me, is a fundamental assault, really, on the institution of the Senate and on the Constitution and the Senate's rules.
We now turn to the votes before us. First is Judge Nancy Maldonado nominated to the Seventh Circuit of Appeals. Anyone seek recognition on her nomination? If not, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Hirono.
Aye.
Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff. Mr. Welch. Ms. Butler.
Aye.
Mr. Graham.
No.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No by proxy.
Mr. Cruz.
No by proxy.
Mr. Hawley.
No by proxy.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
No.
Mr. Tillis.
No.
Mrs. Blackburn. Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
Nomination will be favorably reported to the floor. Next is Georgia Alexakis, nominated to the U.S. District Court for the Northern District of Illinois. Does anyone seek recognition? If not, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Hirono.
Aye.
Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch.
Aye.
Ms. Butler.
Aye.
Mr. Graham.
Aye.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No by proxy.
Mr. Cruz.
No by proxy.
Mr. Hawley.
No by proxy.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
No.
Mr. Tillis.
Aye.
Mrs. Blackburn. Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 13, the nays are 8.
The nomination will be favorably reported to the floor. Next is Krissa Lanham, to U.S. District Court for the District of Arizona. Does anyone seek recognition? If not, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Hirono.
Aye.
Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch.
Aye.
Ms. Butler.
Aye.
Mr. Graham.
Aye.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No by proxy.
Mr. Cruz.
No by proxy.
Mr. Hawley.
No by proxy.
Mr. Cotton.
No by proxy.
Mr. Kennedy.
No.
Mr. Tillis.
Aye.
Mrs. Blackburn. Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 13, the nays are 8.
Nomination will be favorably reported to the floor. Next is Judge Angela Martinez to the District Court for the District of Arizona. If no one seeks recognition, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Hirono. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch.
Aye.
Ms. Butler. Mr. Graham.
Aye.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No by proxy.
Mr. Cruz.
No by proxy.
Mr. Hawley.
No.
Mr. Kennedy. Mr. Tillis. Mr. Cotton.
No by proxy.
Mrs. Blackburn. Chair Durbin.
Aye. Senator Tillis? Let the record indicate the senator from North Carolina votes aye on this nominee.
I'm sorry, Tillis was a no?
You wanted?
Aye.
Aye.
Got it.
Want to announce a roll call?
Great. On this vote, the ayes are 12, the nays are 9.
The nomination will be favorably reported to the floor. Next is Sparkle Suknanan, nominated to the U.S. District Court for the District of Columbia. Does anyone seek recognition? Senator Hawley?
Thank you very much, Mr. Chairman. I had an interesting back and forth with Ms. Suknanan. She's an uncommon nominee, I have to say. This is an individual who represented a series of hedge funds who were trying to extract payments from Puerto Rico during a debt crisis, ultimately forcing Puerto Rico into bankruptcy proceedings. She's certainly, Ms. Suknanan, like any lawyer, is certainly entitled to represent whoever she wants. And I don't think there's any question there's no question of ethical violations in terms of who her clients are. She can represent anybody. And I don't think she violated her ethical responsibilities in representing these folks. I just question her judgment in doing so. And when I asked her about the fact that she was lead counsel, strangely to me, she denied that she was. And so I'd just like to enter into the record this article from the American Prospect, not exactly a conservative publication. The American Prospect, it's entitled, Mr. Chairman, Biden nominee asked about discrepancies in testimony. Thank you. And the point is this: if you look at the court filings, as this article details, she is the counsel of record, Ms. Suknanan is, in multiple of these proceedings with these hedge funds against Puerto Rico. The Jones Day website, that's the law firm for whom she works, praised her as the lead attorney. She was leading the team representing a group of investors in bonds issued by Puerto Rico's pension system. And again, it's her judgment to represent who she wants to represent, and so that's certainly fine. I question why it is she chose to use her legal talents to help drive Puerto Rico into bankruptcy. And I just note that in Congress, on the other side, on the House side, Congresswoman Velazquez of New York has said that her nomination is an insult to the people of Puerto Rico. Those are her words, not mine. I'll let her explain what she means by that. But I've got serious problems with this nominee, given her judgment. I think there's no doubt that she's very able. In fact, part of what she did, as we talked about when she was in front of us, is she invented a new novel theory about why these hedge funds ought to get paid before Puerto Rican bondholders. So the hedge funds got paid first, and the actual citizens of Puerto Rico got paid last, had to have public services slashed, had to have austerity imposed on them. She was so successful in this that a bunch of other hedge funds piled into court and used her theories. So she's very smart. There's no doubt about it. She was a good lawyer for her clients. I just think what she did is objectionable. And I don't like the fact that she wouldn't just admit to us that she's lead counsel on the case. Her own law firm said so. So with the Prospect article lays out some of this, and with those concerns noted, Mr. Chairman, I yield.
I will respond very briefly, but first I want to give the clerk of the committee an opportunity to correct the record on a previous vote.
Yes. On the Martinez vote, the ayes are 13, the nays are 8.
Martinez vote the ayes 13 to 8. So the nomination will be favorably reported to the floor. My only response, Senator Hawley, is that you received a letter from Mr. Brogan, Stephen Brogan, who I understand is one of the lead partners at Jones Day, the firm that Ms. Sunanan was part of. And he said expressly on the issue of lead counsel, regarding the Puerto Rico insolvency matter, Bruce Bennett, one of the foremost insolvency lawyers in the world, was the lead lawyer. So she did not misrepresent her status in that case. I ask that this letter be made part of the record without objection. Did you want to say a word?
All I would say, Mr. Chairman, is that she is listed as counsel of record. And we got a lot of lawyers in this room. I think we are all lawyers. And counsel of record over and over. And her firm held her out at the time as the lead lawyer. It's on their website. So, and listen, whether she's lead or not, it's not that important to me. The substance of it is important to me. And I think that this was a bad judgment call on her part, and I think it really cost the people of Puerto Rico. So I've had my say. Thank you, Mr. Chairman.
Thank you, Senator Hawley. If there's no one else seeking recognition, the clerk will call the roll on Sparkles.